With a big and contentious election coming on, there's a new Hatch Act sheriff in town. Attorney Hampton Dellinger was recently confirmed as special counsel, leading the Office of Special Counsel. For some current topics and its plans for the agency, Hampton Dellinger joins me in studio. Good to have you with us.
Tom, thank you for having me.
And you are replacing the redoubtable Henry Kerner, who has moved on to the Merit Systems Protection Board. But having chatted with you before the interview, you're no slouch either. Tell us about yourself. Where the heck do you come from?
Well, mainly from North Carolina. I was born in Mississippi, raised in Durham and Chapel Hill, North Carolina. Went to University of Michigan for undergrad, Yale Law School. Served as a Deputy Attorney General in North Carolina. I was head of the Office of Legal Policy in the U.S. Justice Department from 21 to 23, and was planning to return to private practice, but was asked if I'd be willing to be nominated to head up the Office of Special Counsel, and I'm glad I said yes.
And what have you found there so far?
I have found an amazingly small agency of incredibly dedicated, talented colleagues. It's daunting to think about it and even to say it. We've got 2.2 million federal employees, and there are approximately 130 members of the Office of Special Counsel. With this incredibly broad mandate, we do enforce the Hatch Act, and we take that very seriously. It's something that I've thought about a lot and have made an announcement about. But we also look to deter government misconduct and, maybe at the core of our mission, protect whistleblowers within the federal workforce to make sure that they are respected and protected.
And what are your observations, I guess, about the comprehensiveness of whistleblower protection, at least legally, in the federal government? Because, every 5 or 6, 7 years, there's a gambit legislatively to extend protections, and that includes the federal contractor side of it. What's your sense of how much the blanket covers that bed at this point?
I know there's more to be done on the legislative side, and that's something I will think about and talk about in the future. But the law on the books is robust. And obviously, Senator Grassley, the Whistleblower Protection Caucus in the Senate have been at the forefront of this effort. But if you look at the protections as written, I think they're very meaningful, and they ought to give a level of comfort that federal workers who see wrongdoing can speak up and should not and will not be retaliated against. Obviously, it's up to our office to be vigorous, and we are, in making the protections on paper a reality in practice. The Merit Systems Protection Board, obviously, as the adjudicator, plays a key role, and it is wonderful that they now have all 3 members of the board. We went 5 years without a quorum. And so those protections, I think, as a practical matter, dipped because the backstop of the MSPB was not functioning as intended. But the MSPB is back. My predecessor, Henry Kerner, was just sworn in, and he has got incredible experience having been at the Office of Special Counsel and knowing what the law is and how to protect whistleblowers. So I think there is a lot of protections that are available right now.
All right. And what about on the contractor side? Any sense of that?
I have not been able to delve into that
Sure.
yet in the way that I wanted. The first thing I did, Tom, when I got to the agency just a couple months ago, is have one-on-one individual meetings with every one of my coworkers. So that was wonderful, meaningful, took some time. It also brought home, though, how small we are, the fact that I could do that and have a meaningful meeting with every colleague. So certainly there is the opportunity for federal government employees to call out misconduct by contractors, but that's an area I want to spend more time looking into in the near future.
We're speaking with Hampton Dellinger. He's special counsel in the Office of Special Counsel, and you mentioned Senator Grassley. This is one area, and generally Hatch Act too, for that matter, that both sides of the aisle, so to speak, pretty much come together when it comes to whistleblowers.
You're exactly right. And that's part of the attraction for me. At the Justice Department, it is a nonpartisan agency. The rule of law is what governs when you're a federal prosecutor, not partisanship. So I was very comfortable with that. I worked in a state attorney general's office. We were focused on the rule of law and not politics. And so the fact that it's really a cornerstone of the Office of Special Counsel, that it is above politics, apart from politics, it's even-handed, that's something that attracted me to the agency, and I've tried to continue that tradition.
And let's talk about your recent Hatch Act guidance, because everyone is kind of bracing themselves for this election. I don't even want to say upcoming, because we're already into the campaign, because the two candidates were decided by the party so early. And because it is, I think it's fair to say, unusually contentious, and there is such a vast contrast between the positions and the candidates, is there, in your sense, maybe a little bit more, I don't know, magnetic attraction to things that would violate the Hatch Act this time around?
Well, I'm sure election years always lead to an uptick in Hatch Act-related questions, for one. But I do want to make clear, Tom, that my announcement about the Hatch Act was not related to this election, was not related to a past president, a current president, or future president, or White House. For me, it was based on coming into the office, looking at the law, and trying to make sure and the agency was following the requirements of the law as closely as possible. So the major point of the announcement, I think, which has received the most attention, is the belief that, as it's written in the law, White House personnel should be subject to the same enforcement scheme as the 2 million other federal workers. And that's in the statute. So I'm happy to talk more about it, but I want to make sure there's no misunderstanding with your audience. This wasn't about this election or any politician. This was about me doing my best to try to follow the law.
And when you refer, again, in the announcement to White House personnel, that's really several types of employee. There is the politically appointed Senate-confirmed level. Then there is a level below that may not be Senate-confirmed. You have the Schedule C, I believe it is, people, and so on. So there's not one type of White House employee. That's
right, but I want to be clear that the law as written has one carve-out, and that is for Senate-confirmed personnel. And actually, as I understand it, I don't think there's many, if any, Senate-confirmed personnel who would work in a typical White House. They are in the rest of the federal government.
Throughout the agency.
So for Senate-confirmed personnel, Congress has said if my office sees a Hatch Act violation, we should report that to the president. And in that narrow category of presidentially appointed Senate-confirmed personnel, the president will decide should there be some type of sanction or punishment for a Hatch Act violation. But for everyone else, the law says my office should take those matters. It has to take those matters. It says my office shall take those matters to the Merit Systems Protection Board. So I understand my office had a different view before I got there, but a lot of that was driven by the lack of a functioning Merit Systems Protection Board. So for 5 years, as we said, there wasn't a quorum. So there wasn't any place to go. But now the board is back. The law is clear. And I think a level playing field for all federal workers, whether you're in the West Wing or Western Kansas or on the West Coast, is the right thing, and it's what Congress has said.
Right, so that means functionally then it's the same for everybody except that carve-out group. A complaint is lodged, and then you pursue it through the MSPB because there is one.
Exactly. And Congress was very clear on this point. Again, the cases we're going to bring, and the office has traditionally actually brought in front of the Merit Systems Protection Board, are the most serious cases: egregious conduct, recidivist conduct, Hatch Act violations over and over again. Our office focuses a lot on education and training. We're trying to prevent Hatch Act violations before they happen, and we're very focused on that. We can issue warning letters. We can ask someone we believe who has violated the Hatch Act to immediately rectify, to delete the tweet that may have sought campaign contributions, for example, for a particular candidate. So we're looking to do lots of things in addition to taking the most serious cases all the way.
We're speaking with Hampton Dellinger. He's special counsel in the Office of Special Counsel. Well, let's talk about what constitutes, Hatch Act violations. I mean, it gets trivial, a button on someone's lapel, or even, I've heard over the years, a bumper sticker, that you drive into the federal garage. And then they're saying people, hey, we're going to, lunchtime, have a fundraising for candidate XYZ. Clearly egregious. And so tell us about the balance of free speech for government people and this Hatch Act situation.
That's exactly right, Tom. Congress has said two things, and the courts as well have backed up Congress on these points, that one, we need to have an apolitical federal workforce, nonpartisan. And so doing politics on the job at the office